public hearing to order. We have a quorum. Hearing is now in session. Would the clerk please call the roll?
Anselmo Galea,
Here.
Alan Kravitz,
Here.
Michael Rossi, Edward Alvarino,
Here.
Pamela Fritz, Christine McKeel, Michael Newton, James Staunton, Maurice Kirkcar,
Present.
Timothy Guerra, Mark Rapiano.
Here. Okay. We don't have a secretary or an alternate, so I'm going to appoint who is here.
Another alternate.
702. I'm going to appoint, well, actually, first I have to see the alternates. I'm going to see Tim for Michael and Mark for Pam Fritz. Mark Rapiano for Pam Fritz. And as I was stating, we don't have the secretary. Who are we seeking for? James. Well, seeking for James Staunton. Didn't forget it. Okay. We don't have a secretary or an alternate secretary, vice secretary, so I'm going to appoint Mark Rapiano for this meeting to act as our secretary. Would the secretary please call read the notice of public hearing?
Planning and Zoning Commission, 54 East Main Street, Clinton, Connecticut. Legal notice of public hearing, Wednesday, September 3rd, 2014. The Clinton Planning and Zoning Commission will hold a public hearing on Wednesday, September 3rd, 2014 at 7 o'clock in the green room of the Andrew Memorial Town Hall, 54 East Main Street, Clinton, Connecticut, to consider the following. 1. AR 14-130, petition to amend the zoning regulations, Shoreline Ice LLC. Amend sections 25.43 and 25.11.21, lot requirements standards, and add sections 10.28.3A6 and 10.28.4B, C, and D. Commercial indoor and outdoor recreational facility. Full text of amendments available in the land use office in the town clerk's office. 2. SE 14-171. 2 Airline Road, Shoreline Pines, accessory apartment, map 14, block 3, lot 1-11, zone R30. The third item, SE 14-172, 316 East Main Street, Northeast Reserve, Inc., accessory apartment, map 86, block 71, lot 61, zone B4. Number 4, AR 14-030, amendment to the zoning regulations and zone map. Section 3, definitions, Section 20, interchange development zone, Section 23, district, Section 24-2, non-residential schedule of usage, Section 25.11, non-residential lot requirements and standards, and zoning map. Continued from public hearing 8/4/2014. Number 5, AR-100, amendment to the zone map, alterations of specific areas in the vicinity of Long Hill Road, north of I-91 and Cedar Road, designated R30 and R60 to R20. Copies of the revised map are on file in the Land Use Office and Town Clerk's Office. At said hearing, all persons will have the right to be heard and written communications received. The application and the accompanying maps are available for public inspection in the Land Use Office of the Andrew Memorial Town Hall. Clinton Planning and Zoning Commission, Anselmo Galea, Chairman, emailed the Harbor News to appear 2 times, Thursday, August 21st, 2014, and Thursday, August 28th, 2014.
Thank you very much. Is there any correspondence on the first one, which is what we're going to consider? AR 14-130, petition to amend the zoning regulations, Shoreline Ice LLC applicant.
Yes, there was correspondence list number 1, received through September 3rd, 2014. For AR 14-30, petition to amend the zoning regulations for Shoreline Ice LLC. One dated August 11th, 2014, letter from Richard Roberts, Halloran and Sage LLP.
Thank you. Is there an applicant or agent for both? Yes, sir.
Good evening. My name is Chris McKeon. I'm an attorney. I've been representing Shoreline LLC, Shoreline Heights LLC, and its principal, Judge Football, who is next to me. Along with Joe, we have engaged the services of a land use specialist attorney with whom I collaborate on many projects, and her name is Marjorie Shansky. She's going to present our application for us tonight.
Good evening, Mr. Chairman, members of the commission. I am Attorney Marjorie Shansky, and I am here with Attorney McKeon for Shoreline Heights LLC. I have a letter for the commission that revises and expands the narrative describing the consistency with the plan of conservation and development for this request. That's Mr. Chairman. There's enough copies, I think, for membership. And if you'd like, I would briefly describe what the goal of each of the amendments is, since there's a small package, or is that redundant to your review?
You may proceed as you wish to
Okay, very well.
present your application as you like.
I'm looking at section 25.11.21. The proposed amendment deletes the language that is indeed stricken. This is a maximum footprint of any single building. And the proposal deletes the exclusion for shopping centers and neighborhood shopping centers and municipal facilities, takes that language out and in its place puts except as otherwise specified in these regulations. And the reason for that amendment is because you have a separate section in your lot standards that governs the exceptions to the lot requirement, and this is a way of adding more flexibility and clarity, really, to the regulation by deleting the few examples that currently exist and simply referring a user to the section that describes a specific use. So that amendment is there actually at the recommendation of staff and seeks to clarify the regulation. Similarly, in section 25.4, coverage in bulk, section 25.4.3 is a deletion of the language that reads, quote, in business, industrial, and marine districts, the total footprint of any single building shall not exceed 40,000 square feet in area, except that shopping centers and neighborhood shopping centers and municipal facilities, libraries, community centers, town offices, public works facilities, etc., shall not be subject to this requirement. Again, we're deleting the language of exception and reposing the specific exceptions in sections that identify the use to which the exceptions apply. So it is removing sort of maybe not an ambiguity, but if things are referenced too many times in the regulations, it can create a confusion. This way, if you're doing a shopping center or a municipal facility, you can find the lot requirements elsewhere. Then for section 1028.3, this is the section, a subsection of commercial indoor and outdoor recreational facilities. we are calling out in new section 6, athletic facilities, that the total floor area of the structure shall not exceed 70,000 square feet. And that no more than 25% of the structure shall be utilized for retail and or food service. And then finally, in section 1028.4, this is in the requirement of a special exception for this facility, that it include under section 10.28.4C that the applicant shall submit a litter control plan. And new section D, if the lot is abutting a residential zone, the applicant shall submit a traffic study. So the effect of these regulatory changes is A, clarification of existing standards and requirements, and B, to permit a commercial athletic facility of 70,000 square feet that overrides the 40,000 square foot limit to which uses in the industrial zones is otherwise subject. And you can see that on the use table that I've included not only in that section of your regulations, but in my letter to you this evening, which was also in the narrative that was supplied at the time of the application. So the reasoning behind the expansion of the floor area of this kind of facility is that, as a practical matter, 40,000 square feet will not accommodate things like indoor ice skating rink facilities, given the nature of those facilities, the size requirements for the ice, and the various amenities that support their use, including locker rooms, including seating, including perhaps an ancillary room, which is typical in this kind of facility, so that either events can be held in connection with use of the ice, even community meetings can be held in connection with the availability of the ice. So that's the rationale for the 70,000 square foot expansion. And the safeguards are that your regulations continue to include the requirements of student setbacks and requirements of specific landscaping and buffering landscaping, adequate landscaping. In a case where it would be adjacent to a residential neighborhood, it would be subject to a traffic study, and all of that would be within the umbrella of a special exception. So there's nothing about adding this language that erodes or dilutes the Commission's ability to evaluate a site-specific application on the merits when it would be presented to the Commission, but it simply permits the nature of the use as it is configured in 2014 to exist. Now, under Connecticut law, you are required to, when deciding on a proposed regulation, to take into consideration your plan of conservation and development. And in evaluating this amendment, we reviewed a few regulations in the zoning map to assess to what extent it would be applicable and how great a use it might have. And we also looked at the plan of conservation and development. And I decided in the body of this new letter to you, a couple of sections in your regulations that I think are particularly poignant. And those include, in the vision statement, quote, Clinton's people come from many backgrounds, but come together in a sense of community that supports activities ranging from youth sports to community concerts. Youth sports being the operative consideration here, and that's from page 201. And then in your section, looking to the future goals and policies, under recreation at page 601, it recites, quote, encourage a wide range of active and passive recreational opportunities that are available to and in convenient reach of residents of all ages. And certainly this kind of use also satisfies those criteria. So we have consistency with the plan of conservation and development, and in the analysis of the special exception and the nature and depth of the review that the Commission gets to perform when a site-specific example would be proposed, give the commission full authority and give the request full consistency with the existing regulatory regime that's necessary for your approval. And then I would share with the commission that a market study has been performed in order to assess the feasibility of an ice rink, specifically in Clinton, and the conclusion of the report included the following: that the overall population, particularly of youth and the income levels in the area, are both above the norm necessary to support a new ice rink. That rinks in the area have no ice time available during the prior season. That there exists currently a base of people in the area who are ready to participate in ice sports, even though it is inconvenient, and by that we mean not close by. It takes an effort and an affirmative intention to go find ice, including high school teams, youth hockey players, and recreational pond skaters. And there's a need for additional athletic recreational activities for children and young adults in the winter. So that is the basis of the request. I would submit that it has consistency with the prevailing documentation that is within the commission's purview to compare it to and study it next to. And with that, I would be delighted, as with my colleagues, to take any questions.
Okay, so does that conclude your remarks in favor, pursuant to the application?
Yes.
Okay.
Unless you think I missed something.
We shall see.
All right.
The hearing is now open to questions from the audience, and I'm going to explain how we're going to do this. When you wish to speak, we're going to begin with people speaking in favor of the application. When you come up, state your name and address. Speak sufficiently loudly so that we can record it. As you see, there's a recorder here at the front of the desk. And you can ask questions of the speaker, the applicant. And I will begin by soliciting comments in favor, if there are any. Anyone in favor?
No.
Mr. Fritz.
Willie Fritz, First Selectman. And although it's specific, the application comes from a specific entity that is involved in a project with the town, it is not specific to this property alone. I think the language changes that are proposed provide an opportunity, because there are other potential developers looking at other properties, and with the restrictions that are imposed on these types of sites in industrial zones in town, commercial areas, it limits the amount of developers that want to come to our town. I think this is a good step forward if the board really wants to provide for economic development, to show that we're making changes to make our town more inviting to developers. This is an exciting project. I'm deeply involved with this project. The state loves the project. I'm not talking about this project. I think the language change, the potential zone change, the change to the regulations is something that is beneficial to the entire town, to other properties in town, and may bring in other developers. So I hope the commission supports this proposed change.
Anyone else that wishes to speak in favor? Yes, ma'am.
Hi, I'm Margaret Wright, 61 Copper Street. I've been a supporting person of this project since the first time Mr. DeFlorville came to propose this. I can speak from experience through the years of not only myself skating, my children skating. There is a need. There is people that are going to come from all over to use it. It is a profitable venture, and I am in full support. And I also agree with the attorney about the expansion. Not only do you need the space for ice, you need the seating capacity, you need a community room, and you need food. So that is very important. So I'm in full support, and I hope it continues to go forward.
Anyone else that wishes to speak in favor of the application? I want to keep this in mind. This is an application to amend regulations. We're not here to decide specifically whether this applicant with the ice skating rink is going to be allowed on this property. That may be for another day. Today, we're just dealing with a zoning change that would obviously impact an application that may be coming, but it also impacts any other application that might come forward in the future, as well as the industrial zone itself and the abutting properties. So I would ask you to speak in favor of the amendment rather than the applicant, because that is what is being proposed. We're proposing, we have before us a proposal for an amendment. So that's what we have to concentrate on. Okay? Anyone in favor of the proposed amendment? Yes, ma'am.
Lori Pacheco Smith, 6 Hilltop View. First meeting I've ever been to, so it's way over my head. But I'm in favor of from what I understood, I am definitely in favor of expanding the size of the amendment because I do think there's a lack of areas for extracurricular activity for the kids in our area. And if we agree with the changes to the amendment, it will possibly allow, whether it's an ice skating rink, another fitness center, or a big rec center with indoor basketball courts, and whatever it may be, there definitely needs to be more of that in this area.
I want to commend you for taking me up on the advice on how to proceed with an application for an amendment.
Did I do it okay?
Yes, very good. Anyone else in favor of the proposed amendment? Anyone else in favor? I do it 3 times. Anyone else in favor? Yes, sir.
Patrick Gilmore, 3 Elmwood Way.
Would you please come forward?
Where is this facility going to be, actually? I first time also on here. Where is this ice, where's this building going to be in town?
Well, there's no building being proposed. This is
Where's
an
the
amendment.
lot, the property?
It's an industrial area. The proposal
Where is it?
It's the town dock. It's the town.
Oh,
The
the old
town
town.
9.26 acres on Old Knott Road.
Okay, but that landfill, I remember at that time, years back, that landfill has went over the years for, with whatever it needs to do in the ground.
Sir, are you speaking in favor?
I'm in favor. Thank you.
Anyone else wants to speak in favor? Anyone else wants to speak in favor? Anyone else wants to speak in favor? All right, now we're going to hear from those who are against this proposed amendment. Anyone against this amendment? Yes, ma'am.
Okay.
Stand.
Good night, Founders Village. I want to thank you first for hearing and voicing my concerns, but I have 5 issues that I'm very concerned about. Number 1, and I'm going to read it from this so that I don't mess up, but how many properties in Clinton would this amendment affect, changing from 40,000 to 70,000 square foot buildings? All right. Secondly, who are the individuals in the Shoreline ice? How many rinks have they built before, and how large have they been? Number 3, how would these structures affect the traffic? We already have congested traffic to begin with. Number 4, wouldn't this amendment contradict the town plan of conservation and development, which seeks to maintain the Clinton small town feel and character? And last but not least, I don't want Clinton looking like New York, Bridgeport, Chicago, with these monstrous buildings in a small New England pristine town. So I am definitely opposed against this amendment. Thank you.
Anyone else wishing to speak against this proposed amendment?
Yes, sir. My name is Merle Wade. I live on 2 Martin Drive. And I have to bend the law a little bit if you give me that privilege. I'm against it. I'm against it. I'm against it from number 1. In 97 and 98, town had to pay to bring water, city water, down Nod Road, Nod Place, Old Nod, part of Airline, and part of River Road because of pollution from this old dump. Now you're going to go and open it up again God forbid, what about the people that live close by there and down Nod Road towards town? This time we're gonna end up with cancer. Now, is the town gonna go and bail us out of that mess? That's all I got to say. But I'm against it.
Okay. Anyone else against this application? Yes, sir.
Leroy Shumbo, 33 Nod Road. Who's gonna foot the bill for the pollution that comes down the stream? Is the town or is the people that own it? Once this thing gets opened
I
up.
once again want to point out that we're here to...
I understand that,
propose
but still in all, you
change.
still gotta look at this.
That will come later.
Okay, as long as it does.
I mean, this is an application to amend the zoning regulations. The underlying aspects that would go in an application pursuant to a special exception would be taken up at a later date when an application is submitted for a special exception.
Okay, so this ain't gonna be the only meeting for this?
No, it's not.
Okay.
If they even come forward. You know, it's all, this is an amendment. It's what I want to make clear. It's an amendment that's being proposed. Whether or not it applies to them at some later date or some other facility at a later date, that's what we're dealing with. It's just an amendment. Okay?
All right.
I just want to be clear. Anyone else that wants to speak against this amendment? Proposed amendment? Yes, ma'am.
I hope Diane Kearney, 85 Old Nod Road, directly adjacent to the piece of property in question. Okay, I'm going to try to speak specifically to changing the zoning on this piece of property, to try to keep away from any feelings. I object to it not because of what's being proposed, but any facility on that particular piece of property, which is directly between us and a woodlot is all that stands between us and this facility. Mostly, my concern is about rainwater runoff if you're going to blacktop any area to put any kind of commercial facility or any building up on that site. All that rainwater currently drains down to the drain system in the road, runs down the road, and drains directly into the pond in the back of our property. We now get, from just people walking up and down the road and driving up and down that road, we get all the time, weekly cleaning out beer cans, soda cans, pollution, plastic, you name it, all kinds of stuff that drains down into the pond in our backyard. We have polluted water on that property now that the town provides us drinking water from previous problems with that. So I don't object to this type of facility at all, or any type of commercial facility, but that location is what I object to. There's wildlife.
She's in favor of the change, but just not her location. Oh, I'm not supposed to see that?
Still, but I understand that the zoning is for this property.
No, it doesn't say for
No,
property.
it's not.
Not specific to the property.
Then
It's not site-specific. That means we're not focusing on this property alone. It impacts potentially other properties. That's why it's a zoning amendment. I know it's confusing, that you have to kind of separate the two objectives. The objective that you're seeing may be coming at some point down the road, and you will have an opportunity, again, at a public hearing similar to this, to speak out specifically on that application, if it ever comes before.
at that site.
At that time. You want to jump ahead. This is an amendment that, in reality, would facilitate a facility of that nature on that particular property.
Okay, then I object to it on those grounds.
Okay. Anyone else against this application? Yes, sir.
Michael Galway, 32 Nod Road. I've got concerns about expanding this and the door that can open up. We're a small rural town. I've always wanted small businesses, mom and pop, that have basically been run out at this point, to come back to town, bring the owners to live in our town, and attract people to visit and buy. I don't want us to become a factory town. I'm concerned about opening that door and allowing this amendment to go through, that's exactly where we're gonna be heading in the future.
Thank you. Anyone else that wishes to speak against this proposed amendment? Yes, sir.
John Hunt Rice, 123 Airline Road, and I'm opposed.
Anyone else? Yes, ma'am.
Don Homestead, One Knot Place, I'm very opposed. The only room to Knot Place where I live, I'm opposed.
Anyone else opposed that wishes to speak? Okay, I will now entertain, let me ask 3 times, to be fair. Anyone else opposed that wishes to speak? Anyone else opposed that wishes to speak? Anyone else opposed that wishes to speak? Okay, we're going to move on to general comments and questions, and then I will give you an opportunity to rebut if it's coming. We're going to have questions ourselves, I'm sure. General comments, questions? General comment? No. You just leave. Okay.
I have a comment, because I'm like the one that says.
You're encouraged by what happened earlier.
Yeah, I understand we're a small town. I've been here 18 years. We've got the outlets here. That's not small, small little shops. We had Cheeseboro Pond, Unilever here. Yes, we moved out, but I would love to see something for the kids, recreational, possibly move in there. So I don't know if those industrial areas are part of what this change is or not, but those are my comments. That's all I have to say.
Okay. I'm going to open it up to the commission for questions of the applicants. So, you ready?
I have a question.
Mr. Kravitz.
I'd like a comment from the applicant's representative. You've sort of lumped together all the industrial districts. In our plan of conservation and development, they are also broken out. And there's a specific, I would like to speak to a specific statement in the industrial park section. In comparison to industrial districts, there should be less traffic impact and a greater emphasis on appearance and landscape, particularly the less traffic impact. And the question really asks you to speak to that general point, and particularly to the inclusion of industrial parks, where that specific statement is made.
I must admit that I'm not exactly sure what you're asking, but let me answer it anyway, because I'm a lawyer and that's what we do. And then perhaps you can clarify.
Well, I'll clarify first.
Oh, okay.
Our plan of conservation and development says specifically that there's intent for less traffic impact from industrial park zones than there is from other industrial zones. It says that specifically. This is a use with, I would imagine under the zoning, if it's a 70,000 square foot building, any 70,000 square foot building would require, with the use of outdoor recreation, which is the amendment is about, would acquire 280 parking spaces. 70,000 times 4 per thousand.
Correct.
How does that generate less traffic? If that is a principle of the plan of conservation.
It's a, well, one minute. The correlation between parking ratios and actual traffic is not really a direct line. It depends on what's going on in the facility. So I think that there's an impression that one can draw from the numbers that the Commissioner has mentioned. But I think that the point of not only the goal as it's articulated in the plan of conservation and development, but the fact that a special exception for specific use would be before the agency. You would have an opportunity to assess whether it satisfies both your regulations and this principle. I think that is also a matter to be deferred to a real request. I will say though, by the same token, and well, perhaps I'll reserve it for my rebuttal, because the comments in Mr. Roberts' letter, for example, are sort of the technical nature where what's been proposed to the commission this evening could be subject to tweaking in a way that still preserved the goal of enlarging the square footage of a future facility, but kept safeguards in place, like you mentioned.
I would add to that in this zone, all the industrial zones, the 40,000 square foot limitation is not applicable to a number of buildings already. This is just one other type of use, an indoor athletic facility. So a shopping center, for example, could exceed 40,000 feet. And depending on how big it is, the parking requirement could be much more than a 70,000 foot commercial indoor athletic facility. So the reason why we coupled this change with the traffic study being a necessity for a special exception application whenever we abut a residential zone. That was the rationale for that.
I'm sorry.
It's our turn.
Sorry?
It's our turn.
I'm sorry.
Okay. Anybody else got any questions on the commission? If not, I do.
I just,
Go ahead.
I was just curious as to the reasoning to choose the I-1, the I-2, and the IP zones, why you chose so broadly to include those, all of those.
To include all of them?
Yeah.
To treat them similarly.
Even though they're spread out diversely across the zone map currently, you know, the sites are very different throughout town.
They are spread out on the zone map in a way, but I also see a coherence to them in the zone map, so that, and of course that would be within the commission's discretion to limit to which zones it would apply, in fact. But I don't see it as being so disparate. I saw it as having really a configuration in the zone map.
Attorney Shansky, I'm going to be technical with you, and I have some technical concerns of the way these proposed regulations are drafted, and I'm a little confused by it. In your statement of support, you state that this provides objective standards and procedures for indoor commercial recreational facilities, and you have those in quotes. Sections 10.28.3A6 and 10.28.4 permitted by special exception in the I-1, I-2, and IP zoning districts. But yet, when we go to those specific sections, you list as a new subset, and I think it's supposed to be a subset, 6 athletic facilities. But you don't define athletic facilities. And I'm wondering, given the fact that to me it doesn't seem like it's a subset, it seems to be almost a standalone new form of facility. Maybe you should have been D, athletic facilities, instead of 6 under indoor recreational facilities. But my concern is, arguably, someone could say that athletic facilities do not have to abide by 1 through 5 directly above.
I think it's an apt question, and I think that it is fixable. The specific language in the title was suggested by staff. And so while I appreciate the distinction, and it can be fixed by adding the label to which it applies.
But you understand what I'm getting at?
Yes. But I don't think that it is altering what's before the commission to insert a word of clarification.
Well, it does. In my opinion, it does. And as it presently reads, I see confusion, and it applies across the board to all three industrial zones. That's not the only thing that I need some clarification about. Incidentally, I don't know if you've seen Helen and Sage, our attorney's letter.
I just saw it, yes.
Yeah, and they raised the same points.
And I wish that they had raised it to us.
It's dated August 11th, so.
And I was in the office this week and did not see it, and nor did they communicate it to us. And we do have no small amount of frustration on that, because we would have, adjusted.
Okay. I'm not sure how we're going to do that at this point, because that is a concern of mine, not just Helen and Sage. I would have raised it with you tonight. Anyway, the other thing is, I'm not sure why, and maybe you can explain it, why you feel that there is a requirement to submit a traffic study in the event of abutting a residential zone, but don't see that somewhere else. I mean, this is a regulation, if amended and adopted, it's going to affect not just your particular site that you may be bringing an application on, but other sites. So shouldn't there be consideration for other sites as well, requiring a traffic study, not just those abutting residential zones? And I'm not sure how that applies, but I just don't like my language.
Well, this one I do believe is readily excised if it were the commission's will to take out in residential, if abutting a residential zone. But the thinking behind it had to do with the industrial zones that are more immediate, the industrial parcels that are more immediate to either other industrial parcels or commercial parcels, and for which there's no pass-through in a residential neighborhood, and that the introduction of a larger scale use out of deference to the commission's discretion in the special exception process, that we would provide that there would be a traffic study for your review. If the commission wants it to apply across the board, we can strike the adjacent to a residential zone with ease.
One final question for me, and again, I mirror what council has pointed out. In section, when you delete section 25.4.3, are you not effectively eliminating the exception for municipal facilities and imposing upon proposed potential future municipal facilities a limit of 7,000 square feet?
That only came to light in seeing that letter, excuse me, and can be fixed by not deleting it as stipulates municipal buildings. I mean, I think deleting the exception restores commissioners'
So you see it.
I do. And I will say that section and 25 one of the other sections, yes, were really recommendations to staff while we were opening the regulations to do some cleanup. Our core interest is in expanding the floor area of athletic facilities beyond the 40,000 cap. So we are agreeable to the notion that if this needs to be tidied up and refined in a way that doesn't have an unintended consequence, we're all about that. Let's fix that.
I can answer your question with respect to items A, 1, 2, 3, 4, and 5, whether they apply or not to the athletic facilities. All of those can apply, from as far as we're concerned.
Yeah, but if some applicant that comes to it with a proposed basketball facility in an industrial zone, that's an athletic facility, I think arguably you could say that, and argue that 1 through 5 don't apply.
Well, I guess what I'm saying is that we'd be happy to amend it to say that they do apply. I do have a question about number 5. because I do think there is a distinction between indoor recreational facilities as opposed to athletic facilities. I think the indoor recreational facility is designed to be like an arcade or these indoor games where there's a concern about supervision if you have a bumper car room or something like that in different rooms. This is an athletic
So
facility.
you don't want an attendant
In the men's room. I don't think we want to pay an attendant in the men's room, but as far as hours of operation, as far as not devoting 40 to 50%.
My problem is, and I know I get technical at times, it's the nature of my business.
We have to be with these.
Okay. It's not consistent, the way it's set.
We can fix it.
Okay, you can fix it. You're either going to amend it or we're going to fix it for you.
Well, let's collaborate.
Okay, so are you proposing that we continue this public hearing?
Yes, please.
Okay. Any other questions from the commission?
Mr. Chairman,
Yes?
I thought the question that was raised about how many properties might be flooding, and the question, how many properties might be affected, the issues that have been raised about this one could be raised with many. And I guess the question is a good question of how many. Have you done any analysis, or could you provide us some information perhaps at the next hearing that would tell us how many, and clearly if you narrowed it, it would be fewer, which might also be less objectionable. If you didn't say that you were going to go into all of these because of many more people.
I did take a look at that, as a matter of fact, and I don't have a specific quantification, but next month I will.
Okay, well, I would ask you to do that. The other thing, is it your understanding that an ice rink can't be built in a facility less than 7,000 square feet?
It is not my specific understanding, but from a use perspective and a feasibility perspective, it needs to be 2 sheets. 2 sheets of ice.
Kind of rinks.
2 rinks.
And those rinks have to all be in one building?
I think they are, by convention, sort of the standard in the trade is that they're in one building.
So what you're saying is you could have one building that would be adequate for an ice rink. That would do everything you need to do, but not for 2 ice rinks.
In the 40,000 square foot, not necessarily, because all of, the existence of one ice rink comes with some ancillary requirements that consume space, like the locker rooms, like the seating. And so you could probably accomplish it, but it would not be feasible because the cost of putting the 2nd sheet is not double the cost, but it provides both the opportunity to have team practice and public using it, and for other uses, other athletic uses. So the need for more than 40,000 square feet is predicated on being more than one building.
I can speak to that question too, from maybe a little bit different perspective. I played youth hockey in Connecticut, and high school hockey and college hockey, all here in Connecticut. I also coached youth hockey for 7 or 8 years. I'm familiar with the high school programs around. One of the big lures of a particular rink located here would be to attract high school programs from towns that currently bus people to Northford, to East Haven, to other places. West Haven. In order to get a high school program to commit to your building, you need a dedicated locker room for that particular team. So what you have is a locker room so that they store their equipment, they come there, it's always there, the bus always leaves from there, and that's the only way you can get them to commit to use your building. So what that means is you have a room that's used by one team. So you can't use it for your youth hockey program, you can't use it for your figure skating program, you can't use it for any other aspect, party rooms, or skate rental rooms, or pro shops. You have to dedicate it. So in today's rink building world, the conventional wisdom is 2 sheets are more profitable than 1. But even if you did 1 here, And I read an article this morning on the International Ice Hockey Federation Technical Guidelines of an Ice Rink. They come to the conclusion that you can stuff the smallest amount of seating that's recommended into, ironically, roughly 40,000 people. But the problem is you will box yourself out of high school programs, junior programs, which in order to get one certified, you need a certain amount of seating in the building. Your Zamboni maintenance, your ice making machine maintenance and facility is way too small. In today's rink, you won't get anybody to come unless you have a decent place to get a cup of coffee or a snack. Because normally you have families with other kids that are running around. Also, other amenities you want there, a place to be warm. So everyone's not freezing watching a game, there's a place to go outside. Ticket sales. So when you throw that together with all of the new energy efficient equipment, solar panels, those considerations would go into the thinking of a modern ice rink. 40,000 just doesn't make it. And I had this discussion with the architect this morning. It doesn't work. So can you fit it? Probably. Can you fit it into a facility that will actually succeed, both in terms of drawing people and financially? No.
Any other questions, commissioners?
I got a question. I've been to North for several times. What's the dimensions of that?
I checked.
Yeah, that's around 75, sometimes 40. Not exactly sure.
How many rinks is that?
It's two.
How many square feet?
75,000.
75.
They also have a pro shop facility, they have a snack bar and an eating area and a pretty sizable workout fitness room between the two rinks. It's also an area where you can observe both rinks, sort of elevated.
I'm not speaking on the ice rink, but for the amendment. I'm just speaking in terms of if there was an ice rink. We're not talking about that, in this amendment, but there are shortages of the rinks. And growing up in West Haven, we were big into hockey. Hampton, all the area towns. There's people have to go really far for ice time, and there is, it's hard to get ice time. And they start out, teams. They start out very young. Coach. It's a great idea, but what we're talking about is changing the amenities, changing the zone. So that's what we have to consider. And there was a good question. It does bring a lot of traffic. You're talking about two rinks, all the players, the moms. They call them hockey moms, not soccer moms, but they got all the kids.
I want to caution you, we're getting too much into details that don't pertain to tonight's public hearing.
Sorry.
That would be an application.
No, it's going back to the traffic center.
You're going past, just like the lady in the audience.
I was going to your traffic center.
Okay. I guess my question is going to, is there a way to accommodate what is envisioned here, and still live with a 40,000 square foot footprint, either in multiple buildings? I don't know exactly how Plymouth Crossing did what they did. At that time, we had some zoning regulations, no? But I guess the question is, could you do it in multiple buildings that would be somehow, would stay within the scale that I hear when people talk about. They want a certain scale, and they don't want this to go beyond the scale. I don't know. The other part of it is that we're going to do scale how that affects the energy.
I'm sure at some point, I would like to hear from a planning standpoint whether this is a good amendment that opens up the door to other such athletic facilities in these three industrial zones, whether it's a bad idea from a planning standpoint. We don't have that at the moment. But I will request it, and I'm going to request it, Eric. And the other thing is, we're probably going to continue this because I heard from the applicant that they have no objection to continuing it to fix massage. Fix, I don't like the word massage. Fix proposed regulation. And so at this point, if there's no other
One other question. First selectman, perhaps, I see you still with us. You made some comment about other, I mean, we're talking about just athletic facilities. Is there some virtue in limiting it to athletic facilities, or?
I thought the intent of the amendment was to any industrial site, not just for athletic facility use, would be for any industrial site,
Right.
just for athletic facilities.
It's for indoor and outdoor recreational facilities.
That's it, period.
Is what it's under in the, actually, it's just
Well, it's
athletic
not
facilities.
right now. That's
Yes, it
why I
is.
want to fix it.
Well, that's what, my understanding was it was for other, any industrial use in an I-2.
It's-
They increased to 40 to 70, and we had a meeting with a potential applicant a few weeks ago, and that's the impression my zoning officer and my assistant zoning officer gave me. So I think we got to clarify what the intent is.
It's for the athletic facilities and.
Because there is another potential applicant coming in with a larger than approved.
To delete it under something else, but it depends on what special exception regulations
I
are
think you
in
better let
under
him know
section
that,
10.
because he was under the impression that this was going to take care of his potential problem.
That, because
Yes,
of what's
but you didn't say it
in,
that way.
that's what under section 10 is okay.
Let's not get too far.
Clear up.
Where we are. Okay, are we done with the commissioners?
One more, I just, currently we have it under 10.28.3, we have it as 6, subject 6. I'm wondering whether it should be brought out to B and also be clarified in the definitions as to an athletic facility versus an indoor recreational facility. It sounds like we're trying to differentiate between the two.
It should be B with a whole subset of requirements like we have under A, indoor recreational facilities. And we may not want to include 5 because it may not apply under athletic facilities. Now, I also want to know, are we defining athletic facilities?
Well, I think we have to, that's what I'm saying.
Is a bowling alley an athletic facility?
I think we have to create we have to add the definition. Whenever we have a new category, we add the definition in our regs. So I think it needs to be added.
So we define by such things as bowling, tennis.
I don't know what an athletic facility is. I have a vision of an athletic
Rodeo.
Rodeo.
Actually, everything.
So, I mean, we need to clarify it, we need to fix it, if we're going to have a proper amendment. Okay? I entertain a motion to continue the public hearing. Well, I haven't heard.
I'll make it.
Mark's got the dates.
Okay, I'd like to make a motion to continue AR 14-130 petition to amend the zoning regulations, Shoreline Ice LLC, for September 9/29/2014 at 7 o'clock in the green room.
Is there a second?
Second.
Any discussion?
No discussion.
Thanks, Al. All in favor, say aye. Aye. Opposed? Abstained? Okay, continue.
Thank you.